Jan Logie.
Tēnā koutou, tēnā tātou, he hui hui mai nei, ki roto e te whare. I would like to add to my colleague David Clendon's voice in offering the Green opposition to this bill and recognising that that voice is in a minority in this House. There are some key reasons that we oppose this bill. One, that it widens the range of offences that call for a reverse burden of proof, despite the challenge that this poses to that basic principle of law, that a person is innocent until proven guilty. We also oppose it because it significantly reduces judicial discretion when hearing bail applications, despite the exercise of discretion also being a very basic principle in judicial practice. Thirdly, it compromises the presumption of innocence in favour of bail, or presumption in favour of bail for those aged 17 to 19, where the accused person has already served a term of imprisonment. And that is despite there already being a provision within the Crimes Act that allows for the detention of people in this age group, and there being no, which really means that no extension of power to detain is necessary. So it signals to us that this is about more of a dog whistle to those who have that misunderstanding of what works in the system, and just the sense of needing to get tough on crime, and that kind of approach will actually make a difference in our community when we know it will not. I would like to also note that from the Human Rights Commission submission on this bill, when they looked at whether there was a basis for going against the Bill of Rights Act, and they noticed that the statistics demonstrate that most people who commit murder do so only once. And the figures appended to the regulatory impact statement itself indicate that homicide and related offences amounted to only 0.1% of offences committed on bail between 2004 and 2008. And the case for change, therefore, effectively relies on the reverse onus preventing less than one instance of a serious violent offence a year. Therefore, hardly the basis for undermining the Bill of Rights Act for many, many people. I would also like to point out and reinforce what my colleague reminded us, that in 60% of cases where people are remanded on bail, though 60% of people are found not guilty. And that's people spending an average, in terms of remand now, are waiting between an average of 1 year and 18 months waiting for a hearing. So I just really want to ask people to think about what those two things together mean. And I would like to now speak more specifically around the provisions in this Act and what they mean for young people, as I've highlighted that we believe that they are more of a dog whistle than anything substantive, any substantive address to reducing crime. And I would like to refer this House back to a piece of meta-analysis research that was done by Youth Affairs in 2000 on the consideration of youth crime, and it was titled "Tough is Not Enough." And they noted that effective interactions with young people will touch on the four cornerstones of a young person's life: family, school, work, peer group and neighbourhood. That they will be fair and respectful in terms of the treatment by the youth justice system, and that those kind of approaches will make a positive difference. But that sadly, arrest has little positive impact, and in particular types of sentences seem to have little impact on offending, except for the situation of probation or restitution and fines. And things that really, really struggle to work are residential interventions. And I think we can consider prison the most obvious example of a residential intervention. And that getting tough on crime offences are almost always fail. And the primary reason for that is that a lot of the young people who are most at risk of being serious offenders are young people who have come from situations where physicality and physical responses and tough responses to anything was the norm. These young people have been inured to that type of approach. What will make a difference in their lives are strength-based approaches. And sadly, this bill is another example of a dog whistle to Conservative interests.
I call the honourable member Jamie